Thank everybody for joining us today. Hopefully this will be informative and we'll have a good time going through this. So thank you all for joining us.
So here's an overview of the presentation. Here's what we're going to cover in the next hour. We're going to start with sort of the basics of regulation under the Clean Water Act, sort of Clean Water Act 101. Then we're going to talk about the law about what wetlands are regulated after Sackett. So our focus is going to be on wetlands, though we'll talk about some other types of waters. Then we're gonna use a case that Mike and I are working on now as a case study. It's a case called United States versus Sharfie. It's an enforcement case here in South Florida, and the case is not over yet. But we're going to talk about it because first we have great images and photos and videos to show you because it'll help. We find that it helps to get specific when we look at these at specific facts when we want to understand the meaning of the Sackett case and how it affects things. So it's a good vehicle to sort of talk about the issues. It's also, we have a preliminary ruling from a magistrate judge that really addresses the different perspectives on Sackett and sort of applies it to the facts. So it's a great way of sort of posing the questions as people delve into these issues. And then last, we're going to save some time for questions and answers. I'm going to say to folks is that should be in the bottom of your webinar screen a Q&A tab. So if you have questions, put them in there. That's the easiest way to show them to us. So when we're all done at the end, we can go through the Q's and A's. And so, Mike, why don't you tell everybody why they should even care about the Clean Water Act and permitting?
I will do that, Neil. And whenever I start talking about this to folks, typically their eyes glaze over. And I have to apologize. And I say, I'm about to tell you much more about this than you ever wanted to know. But it is an important topic. It is important to care about, and it affects you and your clients in a number of ways, principally in terms of time, cost, and uncertainty. So if you're involved in the federal permitting process, it will take more time to go through the permitting process than if you're not in it. There are requirements in the federal process that are not in the state permitting processes, such as an alternative sites analysis. You have to go through that before you can even go to step 2 in the permitting process. So it will take more time. The other part of the timing is that you have to coordinate with other federal agencies. So the Corps will be coordinating a NEPA review, the Endangered Species Coordination with NEMS and Central Fish Habitat. You can find yourself in with the National Historic Preservation Act coordination. And the Corps has its own archaeologist in Jacksonville. So even though you may have your state SHPO sign off, the archaeologists with the Corps may have some different questions or different opinions. So all of that takes more time, takes more cost, and it leads to uncertainty in the permitting process, because the last thing that can happen here is that this gives opponents an opportunity, once the public notice goes out and the project is put on public notice, for third-party objectors to come in and object to your permit or object to the process or somehow get involved in it. So you should care about it because of those things. It's time, cost, and uncertainty.
Okay, so folks, with that sort of like why you should care, let's start out with your Clean Water Act 101. So I just want to briefly go over the basics of Clean Water Act regulation. So the Clean Water Act was passed in 1972, and it's the primary federal law that governs water pollution. So the act regulates the discharges of pollutants and dredged and fill material in every state. So it's national in scope. The primary agency that administers it is the U.S. Environmental Protection Agency. So it's EPA does the overall administration of it, but the dredge and fill program, which is typically the wetland program, is administered by the U.S. Army Corps of Engineers. By the way, if you hear me say Corps here, I'm referring to the Corps of Engineers. And so that's sort of the federal agency overlay, but then the Clean Water Act allows state agencies to be delegated the administration of the permitting program. And so there's two major permitting programs under the Clean Water Act. One is what I'll call sort of the general water pollution program for sort of conventional pollutants. That's under Section 402 of the Act. It's also called the NPDES program. And almost every state administers their own NPDES program pursuant to a delegation. There's a separate program that the Corps of Engineers runs that relates to permits for the discharge of dredged and fill material into wetlands. And that has only been delegated to two states. Florida was the third, but that's in litigation and is vacated by a district court and it's on appeal. So there is sort of a state federal or a federal national standard with some state administration of it. Mike?
Yeah, how does the state regulation and the federal regulation overlap or combine? I like to always go back and think about that in terms of the constitutional underpinnings. And I'm a botanist. I'm not an attorney, so anything I say has no legal import at all. But at the federal level, we're into protection of waters and wetlands under the Commerce Clause of the Constitution. So that is the underpinning constitutional authority for the federal regulation. And if you go back in time, it was very important to regulate waters in the United States. They were the primary avenue of commerce. We didn't have interstates, we didn't have airports, so most goods and transportation was water-based. So that's the federal underpinning, and so we've had, as Neil said, the Clean Water Act since 1972, and the regulations have developed and have been implemented in various forms and fashions since then. The states have their own regulation because, again, under the Constitution, anything that's not delegated to the federal government is to be the purview of state regulation and state governance. So in Florida, and for those that may not be in Florida, we have to talk about the different states and the different regulations. But in Florida, every wetland and every surface water is regulated by the state in one form or fashion. So we don't have any unregulated waters or wetlands in Florida that are not subject to regulatory review and permitting or need for permitting at some level. So that's how it applies in Florida, and what that's resulted in is, in many cases, overlapping and a duplication of efforts in reviewing wetland lines, wetland permits, wetland mitigation, and that's why the state sought to get delegation for the federal program, which it did. And as Neil said, that's in litigation. It's currently been vacated. So in the state of Florida, you need both a federal Clean Water Act permit if you're having activities in regulated waters of the United States, and you need a state permit if you're in state wetlands or surface waters. One other overlap here or significant point is that your state permit under ERP in Florida, your state permit serves as the water quality certification for your federal 404 permit. So you have to have that to get a federal 404 permit. So that's another relationship between the state permitting process and laws and the federal.
Okay, so let me get into a little bit of nitty-gritty here about what are the specific actions that trigger a need for a Clean Water Act permit. So This is basically the elements. So first you need to have a discharge, and a discharge is the addition of something to a water body. The discharge has to be of a quote unquote pollutant. And a pollutant is defined as almost anything, not quite everything, but almost everything. But it includes conventional pollutants like you might think about, chemicals, nutrients. It also includes dredged and fill material that may be placed in the waters. So you need to have a discharge of a pollutant. It has to be through a point source. That's a term of art in the Clean Water Act, which means a discernible, combined, and discrete conveyance. So the way to think about this is think about a pipe or a ditch or mechanical equipment, something like that, as distinct from, let's say, runoff across a field. So something that is confined and discrete. So you need a discharge of a pollutant through a point source to the navigable waters. And that is the key phrase, which is really what this presentation is about. That's the term in the Act. If you go into the Clean Water Act and the definitions, it defines navigable waters to mean the waters of the United States. And everybody agrees that includes some, but not all, waters and wetlands. Now, in terms of the permit scheme, if you get a permit, you have to apply to the Corps of Engineers. And again, at this point, we're just talking about the federal permitting under the Clean Water Act, not the state permitting. And if you apply to the Corps, they almost always issue the permit. I remember several years ago, more than a few years ago, the Corps very proudly said they granted 98.5% of their permit applications. And so there's two different kinds of permits. There's an individual permit that's tailored for a specific project. There's also things called general permits, which are basically categories of activities that the agencies have decided don't have significant impact. So if you fit within the criteria of those general permits, then you're deemed to be permitted. And the key thing about every permit is that there's conditions on it. So there's typically general conditions, and then that are sort of in every permit, and then there's specific conditions tailored to a project. So in a wetland permit under Section 404, you're typically going to see conditions that require the applicant to minimize impacts to wetlands, to mitigate those wetland impacts by buying credits from a mitigation bank, or to do on-site wetland mitigation. And there'll also be provisions in there to minimize effects on listed species, species listed under the Endangered Species Act. So you'll get your permit, but there's conditions on it, which are pretty common to all. Mike?
Yeah, there are things that are prudent to do before entering into the actual application and submittal of the permit. It used to be more common than it is today, but you can still do a pre-application conference, maybe virtual, maybe in person, with the Corps of Engineers. Present the project, talk about the scope of it, talk about the wetland delineation methodology being used, and mitigation concepts. So it is possible, and I would recommend, if you can, do a pre-application conference with the Corps before. It's also really critical to understand, putting the permit application together, the statutes, the regulations, and the policies. So the statutes are I started to say clear, but they're actually not. But the statutes are in print, and you can read those. The regulations should be available and read from the Federal Register. But then there are certain policies that the Corps or EPA will put out that give some guidance. So understanding that and putting the application together with all of that in mind is important, and will help you through the permitting process, because the agency is going to look at all of those things and check their boxes and see whether or not you have given them all the information they need to be able to review your application. As we mentioned earlier, there's also coordination with other federal agencies. So you not only have to follow the procedures of the EPA and the Corps in the 404 permitting process, but also have to be cognizant of the Fish and Wildlife Service regulations, NEPA policies, and other federal regulations. So you have to go through that. And as I mentioned, the Corps has its own archaeologist now, so there may be questions that come up on that. And again, once a public notice goes out, opponents can file a lawsuit, and it can not only be substantive but also procedural. So you could find yourself in a procedural litigation if all of the policies and guidance haven't been followed.
Okay, you also have the risk of enforcement. So if a person does work where they need a permit and they haven't gotten it, or if they have a permit and they don't follow all the conditions, that can result in some kind of enforcement against the person under the Clean Water Act. So I'm going to break this down into two groups. There's government enforcement and there's private enforcement. Government enforcement is like what it sounds, and the agencies have an array of choices. So at the most lax, lightest level, they can do administrative enforcement. Basically, if you've done something that's inconsistent with a permit, give you an after-the-fact permit, maybe have a small administrative fine. But they also have the ability, the federal government and frankly the state government too, when they're delegated the program to bring a civil enforcement actions. That's filing a civil lawsuit in federal court to seek declaratory and injunctive relief, and potentially could assess daily civil penalties. And then in cases that they think are very egregious, they could also bring criminal cases to enforce the same laws. And I started out in this business a long time ago, but I was in the environmental crime section of the Justice Department. I used to do criminal cases, including wetland cases. So that is an option for sort of egregious cases. Also, just folks need to be aware that there's a so-called citizen suit provision of the Act, which means that individual private persons or organizations, often environmental groups, can file lawsuits against people too, claiming that they have done some work without a permit or in violation of the terms of a permit. And they typically get injunctive relief, but they can also get their attorney's fees. So let's talk now about Sackett and what's the new test. Yeah.
Yeah, let me just add on two thoughts. One is, if you need a permit, make sure you get it. If you don't need a permit, stay out of the permitting process. And one other thought, again, having done this for a while, years ago, sometimes I would hear the comment, well, it'll be easier to get forgiveness than permission. That approach went out of style decades ago. So I wouldn't encourage anyone to adopt that philosophy. You do not want to be in the enforcement arena. Thanks, Neil.
Yeah, no, great. Mike, you said you were not a lawyer, and it's true you're not a lawyer, but you're pretty good at this, having done this a long time. But I do want to say that I'm an amateur hydrologist. And so anyway, it's a joke. I'm sorry. I'm just a lawyer, but Mike's a better lawyer than a lot that I know. Okay, let's talk about Sackett and what is the new test for which wetlands are regulated. So again, as I said earlier, the Clean Water Act only regulates discharges to the waters of the United States. And that term is not defined in the statute and has been interpreted by various regulations and court decisions. So everybody agrees that waters of the United States does not include all wetlands and all waters, but the debate is over which ones count and which ones don't. And again, I want to emphasize, if you could avoid doing work in a regulated wetland, then you don't need a Clean Water Act permit. Because again, you could have a discharge into a wetland, but if the wetland's not regulated, then the Clean Water Act doesn't apply. So this geographic scope is an important issue, especially in connection with wetlands. So the definitions of waters of the United States has changed over time. Over the decades, the EPA and the Corps of Engineers have adopted various regulations seeking to define that term. And if you go back to the 80s, there were some regulations that were adopted that pretty much regulated all wetlands in the United States. But in 2000, the Supreme Court started to issue cases cutting back on that. So the first was the so-called Swank decision, which reduced regulation over isolated wetlands. Then in 2006, there was the Rapanos decision, which reduced regulation over adjacent wetlands. In other words, wetlands that are adjacent to some kind of tributary. The thing about Rapanos is that there was no one opinion that commanded a majority. So there's a fractured opinion, which then led to different competing tests and a period of confusion. So what happened is then the agencies went through a period of time where each administration would promulgate. We did this 3 administrations in a row. The Obama administration starts and they promulgate a regulation which defines waters of the U.S. in light of these Supreme Court decisions. And they were expansive in their views. Then all the opponents file lawsuits, get it enjoined. Then Donald Trump gets elected president, and they rescind that regulation and do their own regulation, which reduces the scope. Lots of lawsuits on that, challenging it. Then Joe Biden gets elected. He rescinds the Trump regulation and does his own, which increases the scope again. And now maybe we're about to see this movie happen again. However, what changed was last year, the Supreme Court issues the Sackett decision, and this has a definitive standard for which waters and wetlands are regulated, and it commands a majority opinion. So it's different now as we actually have much clearer guidance from the Supreme Court about the scope of regulation. So let me just walk through what was the pre-Sackett scope of regulation, and then what is the post-Sackett scope of regulation. So pre-Sackett, this is the before. Here's what was regulated: traditional navigable waters. What do I mean by that? You can actually navigate a boat on it, and that includes tidal waters. Tributaries of traditional navigable waters. And the agencies would essentially regulate any body of water that would contribute flow to a traditional navigable water, at least seasonally. So they would include not only rivers and streams, but canals and most ditches. And they would, based on the confusion over the Rapanos decision with the competing opinions there, they would include tributaries that either were quote unquote relatively permanent waters. We'll talk more about that in a minute, or those that had a quote unquote significant nexus. So there's these 2 competing tests. But basically, anything that contributed flow downstream was fair game under the old set of rules. And then last, the agencies would regulate adjacent wetlands. So these are wetlands that are adjacent either to traditional navigable waters or those that are adjacent to a regulated tributary. And they would also regulate those with a continuous surface connection. We'll get to that in a minute, or if there's a significant nexus. When Sackett comes out, here's how the test changes on its face. It's not all that different, but there's some important differences. First thing, traditional navigable waters still regulated. Everybody agrees with that. Then the tributaries that are regulated are only those that are relatively permanent waters. And here's what they said in Sackett. The Clean Water Act's use of waters encompasses only those relatively permanent, standing, or continuously flowing bodies of water forming geographical features that are described in ordinary parlance as streams, oceans, rivers, and lakes. So notice the word ditch is not in there. But it's now that significant nexus test is gone, right? And then the post-Sackett, certain adjacent wetlands are regulated. And they say the wetlands that are regulated are those that have, quote, a continuous surface connection with the relatively permanent water, making it difficult to determine where the water ends and the wetland begins. And they also say in a footnote that if you have a barrier separating a wetland from a water, it removes jurisdiction. What's the barrier? It could be like a berm, for instance. So this is how the language changes in Sackett. And so, Mike, maybe you want to highlight what are the open questions after Sackett that people are now grappling with about the scope of permitting jurisdiction?
Well, Neil, after your explanation of post-Sackett, it seems real clear what the answer should be. There probably should not be any open questions. But there are.
That's why we're in business.
Well, that's another matter. The questions that are out there now have to do with what are tributaries or man-made ditches tributaries. As Neil pointed out, the Sackett decision does not identify ditches as tributaries. In fact, it has a comment that would indicate that the ditches are not. But if you go to the agencies before EPA, they will tell you that ditches are tributaries. They can be tributaries. And inexplicably enough, I can't explain this, is that you could have a traditionally navigable water or relatively permanent water, and you could have a ditch that would connect to a otherwise isolated wetland. And if water can sometime flow through from that wetland through to the ditch to the TNW or the relatively permanent water, then that establishes the continuous surface connection that makes it a wetland, even though the ditch may not be a regulated water. Again, I can't explain that, but you will be told that. So there's an open question about ditches, and also about wetlands and the continuous surface connection. Right now, in my current practice, if we go to the Corps of Engineers and ask for a wetland delineation and go through the process, we will be told that any kind of ditch, swale, a place where water can flow after rainfall, seasonally or in any way, then that would establish the continuous surface connection, which has gone even further than pre-Sackett, because at least pre-Sackett you had significant nexus tests, which is not there now. So that's sort of where we've gone. The pendulum's gone even post-Sackett, far to the position of any man-made ditches or swales or conveyances would be a tributary. Then you get into wetlands. So only wetlands, as Neil said, only wetlands that abut, connect, physically touch a relatively permanent water or traditionally navigable water can be adjacent wetlands. And those wetlands have to have a continuous surface connection. There's another statement about there being an additional requirement that must be hard to distinguish from a nearby TNW or relatively permanent water. I read that as not two tests, but one continuing explanation of what is a continuous surface connection. Now, it doesn't say continuous surface water connection. However, as we'll explain in the case study that we're going to go over, the federal judge did point out that if you didn't put water in there, that phrase had no meaning. So really, we're talking about continuous surface water connection and a touching of that wetland with a surface water connection. Now that does not say saturated soils or a wetland that's only saturated soil wetland and doesn't have surface water. So these are all the questions that are still out there and we're still arguing about, even though Alito, I believe in his mind, thought he had answered those.
Okay. So Mike, you want to just briefly talk about implications for regulated parties? Yeah,
I think part of the conundrum that the regulatory agencies, and I shouldn't speak for them or say what's in their mind, but they've been regulating waters and wetlands in a certain manner for under these the whole history of the Clean Water Act in a certain way. And the Supreme Court under Riverside Bayview Homes, under Swank, under Epanos, and now under Sackett has given clarification to what it means to be a regulated water of the United States. But these arguments still persist, and it may require yet another Supreme Court clarification to to come up with what is actually the final determination. But in reading Sackett, I I thought Alito made it pretty clear, but evidently everybody that reads it doesn't read it the same way.
Yeah, so I just want to say something here is, so what we have is a moment here in time. We'll see how long this lasts, where there is the agencies believe they regulate one thing, but then if you read Sackett, you could argue that actually another thing is regulated, and it's in the process of being worked out. And so this creates both confusion, but also creates opportunities for people as they deal with their properties. I just want to say is what's going on right now is so Sackett came out last May of 2023. Since then, the cases that are interpreting Sackett and applying it are typically enforcement cases. So these are cases that are being brought by either the government or by private parties, and they're litigating over whether a specific piece of property is regulated or not. And then this is leading to some decisions. And so here's a list on this slide of the major decisions that are out there. Everything is case specific, and every case is sort of different, you know. So the Lewis case is in the Fifth Circuit. They found that the wetlands in that case were not regulated. That is sort of a tortured procedural history. It went back and forth with lower courts. The Andrews case from Connecticut is fact specific about wetlands in Connecticut, but this one I put an asterisk next to it because the defendants were not even represented by counsel. They did it on their own. They didn't even file papers with the court. So the court pretty much just adopted the government's view of things. The San Francisco Baykeeper case is a citizen suit that generally found areas to be regulated. But then you have three cases, or you have a couple of cases where the courts found on a preliminary matter at the motion to dismiss stage that maybe they had not pled enough facts to make them regulated. So these cases, this is where the action is right now when it comes to understanding the scope of Sackett. And so this takes us now to the Sharfie case. And so this is sort of what inspired Mike and I to do this presentation. So this is a case that we're involved in. It's in Florida. And what it is that this is one where we not only have completed discovery, we have photos and videos to show you, but we also have a preliminary ruling from a magistrate judge. So it frames the issues, and it's very helpful to think about these issues by looking at the Sharfie case. So let me just give you the basic facts. And by the way, let me just give a shout out here. I hope they're watching, but you know, there's obviously a team working on this, and there's two lawyers who work directly with the client, and Josh Myron and Chris Hamilton. Hopefully they're on. Good guys, good lawyers. Nothing good in life happens without a team. So we've been working in the trenches on this one for a while together, and it's nice to have them. So in the Sharfie case, the client purchased 10 acres of land and incorporated it into a nearby farm. And this land is approximately 2 miles from the nearest natural stream that's called Bessie Creek. But there are some man-made ditches that are near the site that are connected to Bessie Creek downstream. And the defendants preserved a portion of the wetland on the property, but they did earthwork in other portions of the wetland. They never obtained a Clean Water Act permit, believing that they didn't need one, and the federal permit. So the court was not happy, and the Justice Department brought a civil enforcement action against the defendants, seeking civil penalties and injunctive relief. So that's the case that we're working on in the Southern District of Florida. So we got Mike, why don't you walk folks through sort of the images here so they can sort of have a sense of this?
Yeah, Neil, if you'll use your pointer.
Yeah.
If you start on the top right corner of this serial, you have the St. Lucie River. St. Lucie River is clearly a navigable water. Just to the east of that is the Atlantic Ocean, which is clearly a navigable water. So that's the traditionally navigable waters are there. If you go about 10 miles to the southwest, you'll see a little box that says site. That's a 9.92 acre site that was the subject of this litigation. There's some important points in between. If you look at the underneath where it says Bessie Creek, there's a bridge there. That's the point where all parties in the litigation said this is where the tidal water, the up and down tidally influenced waters extend to this point. So that is clearly a regulated water where it's tidally influenced to that point. Upstream of that, you have a natural portion of Bessie Creek. And I say natural, it's not been channelized. It has the sinuosity of a natural stream and it's fresh water. And it goes all the way up to an area that's identified as the HWTT. That's a hybrid wetland treatment facility, which takes water from the upstream area that would flow into Bessie Creek and treats it. So upstream of that, you have an east-west ditch. And we contend it's a ditch because it's straight lines, and it was part of that 1920s system that of a project, drainage project for this whole large area that Neil is putting his cursor around. So out of that, this channelized ditch then goes further to the west, and you reach a north-south ditch. That north-south ditch flows or is located on the west side of the 9.92 acre site. So just to orient you with the key hydrologic features that were pertinent to this case. Now, if we go to the next slide, we can look at how the various parties interpreted these drainage features. On the left side of the screen, you see an exhibit. I believe this came from the federal government's case and pleadings. And what was contended there was that on their 9.92 acre Sharpie site on the bottom, the wetlands were on the southwest corner and extended all the way up to the boundary of the property. And then there were wetlands that extended from there all the way up north and northwest, eventually connecting to the east-west ditch, which the federal government called Bessie Creek, but the magistrate said no, it's a east-west ditch. And then there was some breaks in the berms, so water could, under flooding conditions, could flow through those berms breaks and then get into the east-west ditch. And then the water had to go through a series of wetlands, get into a ditch on the far west side, the 84th Avenue ditch, and go down and connect into the east-west ditch. So that's the contention. And as we started this case, this was the connected allegation of the federal government, and that's what they presented in their depositions and expert reports. The wetland on the southwest portion of the 9.92 acre site had been inspected previously by the South Florida Water Management District, and on the map to the right, you'll see the boundary of that. So actually, an environmental consultant flagged that wetlands before anything was, or little of anything was done out there. And then it was inspected by South Florida Water Management District, and they approved that plan. The federal government obviously took exception to that and said, no, it went all the way up to the boundary. The map on the right also is a National Wetland Inventory map. And those of us that work in Florida realize that National Wetland Inventory maps are not wetland jurisdictional maps. On the face of it, they say they're not. But it does give you a view on how the landscape is laid out, where you have connected wetlands, isolated wetlands, uplands, So it gives you some sense for that. So the areas that are in light green, northwest of the Sackett site were determined on National Wetland Inventory to be wetlands, but isolated and not one contiguous wetland system there. So this is part of the disagreement, and it sort of framed the argument for the litigation.
Mike, you want to talk about this? Just
Yeah,
briefly what this is?
To give some sense of what we were talking about, the photo on the left shows the channelized east-west ditch that goes and connects to Bessie Creek. In this situation, there was water in that east-west ditch. The area where the red area is on the east side of this is where the north-south ditch comes into the east-west ditch. And the north-south ditch is the one that is on the west boundary of the 9.92 Sharpie site. So that gives you some sense for that point of connection. The photo on the right shows the east-west ditch in a more dry condition. May have been saturated soils at that point in time, but there was not continuous standing or flowing water. We go to the next. Actually, Neil is going to give us a bird's eye view of how all this fits together.
Yeah, so look, I'm going to move through this fairly quickly because we're about 15 minutes left. I want to make sure we have some time for some questions. But the main point is this. So we wanted to show people this is what it looks like, because I bet most people on the phone are thinking about their own property somewhere, and they're thinking about how it looks, and they're asking themselves, is this regulated or not? So I want to briefly show you an aerial photograph, aerial video. So what this is on the right, this is Google Earth, and you can see the locations. This is our 10 acres. And this is going up the north-south ditch. And this was taken in April of 2022, I think, and is just flying over to see what it looks like. So this is the dry season. You know, the government's exhibits are in the wettest month of the wet season. But this is the north-south ditch. You can see it there. And at this point, there's no water in it at all. And the government's position, if you remember that exhibit that Mike just showed, is that all of this stuff they think is basically a wetland, all of it, and going up to these other ditches to the north. So I'm going to speed along here to give you a sense of this. And I know it's going to be choppy here, but I'm just move across the landscape. But this, I bet a lot of people on the phone here have seen places like this, which are, this is pasture land, by the way. There's cattle out there. So then and the government claims that all of this you're looking at is a big wetland. And then it approaches, and this is where they say in the wet season, the water, this is the connection to these ditches. Then it comes over here, there's a road, 84th Avenue, and there's a roadside ditch. And you can see the roadside ditch right there. That's their position that is also a waters the U.S. And then this is the east-west ditch where it goes under the road. And you see there's like a puddle here and a low spot by the culvert. And now we're turning east on the east-west ditch. And you see there's the puddle, and then it ends and it's dry again. And so this is what it looks like going on the east-west ditch. And I'm just going to go up here again. This is where they believe the wetland connects. We're about to show you a photo of that spot, by the way, in a minute. And this is what they say this is what it looks like. So let me just identify, here are the theories of the case. So here's how the two sides applied Sackett to these facts. The government's theory is that those seasonally wet ditches are relatively permanent waters. So they claimed the east-west ditch, the north-south ditch, and the ditch along that road I just showed you. And their theory was it's a relatively permanent water because it was wet in the wet season. And never mind that it was dry in the dry season. their position is that the wetlands are regulated if any one part touches the edge of the ditch. So it didn't matter whether there was surface water on it. As long as the wetland soils come down to the edge of the ditch, it's regulated. And their theory is that the wetland on the defendant's site was part of this much larger wetland. Remember, their exhibits sort of included everything. And because a part of the wetland, about a quarter to a third of a mile away, touched the east-west ditch and the 84th Avenue ditch, that means the whole thing is regulated. So that's the government's theory. Our defense theory is that a man-made ditch doesn't count if it's wet only seasonally. And so these are intermittent seasonal ditches here. They're dry in the dry season, and you just saw them in the dry season. Our position also is that Sackett says wetlands are only regulated if there is a continuous surface connection. And we think that means surface water connection. So it's not enough that the wetland simply touches the ditch. There needs to be surface water on it. And then we also argued, Sackett talks about the wetlands have to be hard to distinguish from the water, from the ditches. So that means something, and you need to have a hard time telling it apart. So let's just look at this. So this is, again, on the left. We're in the north-south ditch. Mike took this photo looking at the east-west ditch in the dry season. On the right, that's an exhibit from the government, an expert. It's the wettest month of the year in August of 21. And standing in it, you see there's water in the ditch. So here's the question. Are those relatively permanent waters? That's the question. Mike, what do you think? Or maybe you want to say, frame the discussion on it at least.
Yeah, that's the question. And did Alito, when he said that it needed to be a relatively permanent standing or flowing water, did he mean to indicate north-south ditches like the one on the left? I'm standing right in it and it's dry, going into the east-west ditch, which is basically dry. It's a little puddle right in front of that, and then it's dry to the east and west. Or seasonally wet areas that is depicted in the photo to the east, to the right. So that's the question. How wet does it have to be? We've been wrestling with that question for decades.
Let's look at the next one. Okay, here's a photo of, this is from the government, one of their experts. That's a gentleman from the Corps of Engineers. So he's standing next to the east-west ditch, again in August of 21, so the wettest month. He's standing in an area that they have identified as a wetland, and he dug a hole in the ground, and he's measuring how far below the surface is the groundwater. And you can see it's a couple of inches there. He's holding the measuring stick. So does this show a continuous surface connection?
Well, that's, again, the key question. If you have a traditionally navigable water, a relatively permanent water, and for the sake of argument, let's say that's one there where it's got the red arrow. But you have what are wetlands that meet the wetland definition test under the 87 manual. But you do not have any continuous surface connection, then is that wetland a regulated waters of the United States? The way I would look at this is, if you think about as you've driven around Florida or other parts of the country, you see a river, and the river's got a channel in it. And then often next to that channel, you'll see marshes. And the water in the channel and in the marshes go up and down the same, and they're all part of one system. And so if that's the case, then I would say that those marshes are adjacent wetlands to that traditionally navigable water. But where you don't have that continuous surface connection, or you go 4 miles or 10 miles up ditches, and there's no way for the water in the traditional navigable water or the relatively permanent water to get into the wetlands. So it's really a distinction between whether or not water can flow from uphill downhill and make a continuous surface connection, or does the water from the traditionally navigable water or the relatively permanent water have to come up and cover the wetland and make that continuous surface connection? It's two approaches, two questions, two situations.
Yeah, I also want to point out something, Sackett talks about that there's a continuous surface connection such that it's hard to distinguish between the wetland and the water. So, one of these, I actually like this photo because I asked myself, is it hard to tell the difference between the wetland and the water? If you're going to accept that the ditch is a regulated water, essentially the wetland is the bank of the ditch. If I can tell the difference between it, doesn't that say it's not regulated? The government's view is that language about distinguishability in Sackett is just descriptive, that by definition, a wetland that abuts a ditch is indistinguishable from the ditch, basically, is their position. I don't agree with it. But anyway, these are the questions. This is how we would argue the law applies. So we have a report and a recommendation from the magistrate judge in the case on the summary judgment. So looking at the facts, and the report concludes that the man-made ditches are not regulated, especially if they're only intermittently wet like ours. That there has to be a continuous surface connection between the wetland and a regulated water, which means there's surface water there covering both. And that the wetlands are only regulated if they, as a practical matter, are hard to distinguish from the regulated water. So that's what the report says is the law. And then conclusion was our three ditches were not wet enough to be relatively permanent waters. There's no continuous surface connection. There's no surface water. It's continuous is the language in the statute, and you can easily tell the difference. So this is how the judge applied the law, but you can sort of see it frames the issues very nicely as going forward. So let's briefly talk a bit here about the last couple slides here, implications for project permitting. So let me just say is that, basically Sackett and these enforcement cases that are coming out in the last year and a half indicate that fewer wetlands are regulated than the agencies believe. Exactly what it is depends on the case. All these cases are case by case. But it is common for the agencies to assert jurisdiction over wetlands that some courts say are no longer regulated. And so there is a bit of play here in terms of what's regulated or not. And this is probably going to be a gray area until there's more court rulings that establish what rules are applicable. By the way, you could have another round of this like bouncing regulations with the new administration. That could happen, but probably won't happen real fast. Takes time for it to happen. You're probably looking at the effects of court decisions here and how this is going to play out. And Mike, maybe this is our last substantive slide before we go to Q&A. Maybe you want to just outline some sort of potential strategies that people can take in this environment for Clean Water Act permitting.
Just quickly, I've been studying wetlands since a year before the Clean Water Act. I've never seen the situation as uncertain as it is today. So as the regulated public, what do? Do you go to the EPA or court and ask them if you need a permit? That's one option. They're gonna tell you, unless they've changed their mind in the last 48 hours, they're going to tell you that that any water connection establishes federal jurisdiction, and you need a permit. So you need to apply for a permit. You can request a jurisdictional determination. There's a formal process for doing that at the federal level as well as the state level. It takes time to do that. Any of these requests we've made, the Corps sends them to EPA, and it takes months and months and months and months for EPA to finally render an opinion to the Corps about whether it is or is not an isolated wetland, for instance. Or you can conduct the work without a permit, which I would never recommend without some sort of further review of it and documentation of it. So that's sort of where we are right now, Neil.
Okay, so let's do this. Let's do some Q's and A's, and let's do the questions. So let me see. I'm going to stop sharing the screen here, and let me see if I can find some of the Q's and A's here. So, okay, the first question is, what policy or enforcement changes do you see happening next year in the new Trump administration? I'm going to say to you that I think we're likely to see the new administration be much more sympathetic to our point of view, and for instance, in the Sharfie case and our reading of Sackett. However, I'm just going to say to everybody, it never happens fast. There's all this talk in the political season on day one, this or that's going to happen. It never happens on day one. The history of these regulations, for instance, has been with the last few administrations as it takes months, if not years, to do these things. So there'll probably be a change back to sort of having less regulation, but it won't be immediate. Mike, do you have anything you'd add to that?
No, I talked with a colleague that works out of headquarters in Washington with the Corps and asked the same question. And everybody's sort of waiting to see. But we've all been through pendulum swings before over the last 4 decades or so. So you just have to wait and see what policies come out, what guidance we are providing.
Right. And I think, so there's another question here that basically is this very similar thing that I'm just not going to cover it. Look, the president can affect this stuff, but it just takes time. These are rules and regulations. It's not going to be immediate. I think we're probably more looking to the cases. There's another question here. When do we think the court is going to rule in the Sharfie case? We don't know. The case was filed in 2021. It took nearly a year from the filing of the summary judgment motions to get the report and recommendations. So judges are busy. So we'll see. Hopefully sooner rather than later, if they rule the right way. And there's also another question here about, are there other cases that are pending which will further illuminate these issues? Well, I listed some. And I think that, it's a lot of it, stay tuned. I would say, though, the cases that I'm watching, if you're in Florida and the 11th Circuit there's this case called Glenn Environmental Coalition, which is a case in the Southern District of Georgia that's now an appeal to the 11th Circuit Court of Appeals. And this issue goes to exactly what Sackett means, though not on as well-developed a record as we have in the Sharfie case. That's one to watch, but remember the courts move very slow. Mike, what do you think? What are you watching in terms of cases to see how these issues will be clarified?
Well, folks are talking about it. I'm talking to people in Georgia, South Carolina, North Carolina, projects all over the Southeast, basically, and everybody's waiting to see. Just one footnote on the Sharfie case, Neil, that is unique, I think, is we started the case under pre-Sackett, and then we ended it post-Sackett, which meant that the experts had to do expert opinions and depositions under pre-Sackett. And then when Sackett came, we had to do them under post-Sackett. So there was 2 sets of expert opinions and 2 sets of depositions. The judge didn't allow us to go gather any data, but just take the same data and apply it to Sackett. So that was unusual in my experience. So I don't know. We just we'll have to wait and see, Neil.
Okay, I got one last question. How does Endangered Species Act affect determinations of go or no go affect 404 permitting in Florida? And Mike, do you want to take the shot at that one?
Yeah, that has been the pivotal point relative to assumption and the vacating of assumption, is whether or not the assumption process properly took into account threatened and endangered species. And so that's a pivotal point there. The state and EPA, when they did the assumption, thought it did. They used a model from several other states that had done this, but then there were opponents from the private sector that, and maybe some governments that took exception of that, and that led to the litigation we're still in and the vacating of the assumption process in Florida. So that was the key point. It wasn't about wetlands. The assumption was not about wetlands. It was about whether the Endangered Species Act was properly applied when they came up with the assumption process.
Let me add something else in the Endangered Species Act. That's something that takes a long time. Almost always the Endangered Species Act affects permitting, just the time it takes to coordinate with the wildlife agencies. And the question for that coordination is supposed to be about whether the project essentially will cause the extinction of the species, which is almost never the case. it does give you some protection against the take of a species, which would be actual physical harm to an individual, let's say bird or animal. But remember, if you can avoid Clean Water Act jurisdiction, it often means there's no need to do that Endangered Species Act coordination. You can't hurt a listed species. You can never do that. But on the other hand, the reason that the Fish and Wildlife is involved in the consultation is because the Corps itself has to take a federal action. So the Endangered Species Act only requires consultation with the Wildlife Agency if there's a federal action. So this is why the Clean Water Act permitting is so important. This is the trigger that gets the ESA involved, which is one of the reasons why this is very important. Got one last question here, and it's the last one. I'll read it. What bearing might information from historical maps or aerials prior to land or water courses being modified have on permitting? Would examples showing pre or post development hydrology be helpful? Mike?
Yes.
I always do that.
I think
great stuff.
Always get as much information as you can. Historical aerials, old USGS topo sheets, anything that can give you good information on the lay of the land. So you can
Let me just say in the Sharfie case, when we started out the case, it's in the complaint filed by the Justice Department about referring to the east-west ditch as the upstream reach of Bessie Creek. And it was Bessie Creek, Bessie Creek, Bessie Creek. Well, we did our work and realized that ain't Bessie Creek, that's a ditch. And they may call it an upstream reach of Bessie Creek, but it's a man-made ditch that's 80 years old or about that. And the government, of course, had to agree. It's a very different story if you're telling whether the wetland is connected to a creek or a stream, because that's the language of Sackett, versus if the wetland is nearby a man-made ditch. And so that was an important fact for us to bring out because it gives context. I bet everybody listening to this has a different reaction if you say the wetland's near a ditch than if it was near a natural stream. Well, folks, thank you so much for listening. We really appreciate you all coming and spending the time. We hope this was helpful, and we hope everybody has a great day. So thanks much.
Thank you all for coming.